Hey there, we're back in the Law Shanty. So we're bucking up on the holidays. You can see I got my holiday pocket square, my holiday turtleneck. You can see my Charlie Brown tree in the background there with my new Law Shanty sign. Since we're bucking up into the holidays, you guys are going to start having problems with people calling in sick like you weren't having them already. Those problems are going to get worse, not better. So I thought what we would talk about for a minute is the issue of what we can ask people when they call in sick about why they're not coming to work. And then we'll pivot that a little into what your confidentiality requirements actually are when somebody tells you they have COVID. When the answer to the question is, I'm not coming in because I have COVID-19, I tested positive, or I have the symptoms. So let's start with this little scenario. We got our buddy Chauncey, and Chauncey calls his boss, and he says to his boss, hey, boss, I'm not coming to work today because I don't feel well. And the boss says, what do you mean you don't feel well? What's wrong with you? And Chauncey says the following, I don't have to tell you that. HIPAA says I don't have to tell you that. I have a HIPAA right to keep my medical information confidential, and I'm not going to tell you why I'm not coming to work. Is that true or false? That's false. It's wrong. It's wrong. It's wrong. It's wrong. I want to get through this quick. I'm not a HIPAA expert, but that is incorrect. HIPAA doesn't work that way. What HIPAA prevents is from a covered entity from telling third parties personally identifiable health information. And I might have gotten some of those words a little wrong. If you really have a HIPAA question, you should be calling Norbert Kugler or Stephanie Grant from our office. But that's not what HIPAA does. HIPAA only applies to covered entities. Generally speaking, covered entities are healthcare providers, doctors, nurses, stuff like that, healthcare clearinghouses, and your health plan, and the business associates of those people, like the TPA that helps you with your health plan. It's not the employee, and it's not you as an employer. That's not what HIPAA is about. So when that employee says to you, I don't have to tell you because I've got a HIPAA right not to tell you, that's wrong. That's not true. And if the employee won't tell you why he's not coming to work, you can take action based on that. You should call us before you do, but you can because we got lots of protections now. Now, just because HIPAA doesn't cover that employee's confidential health information doesn't mean there isn't coverage for that employee's confidential health information. There's a lot of statutes that have confidentiality provisions in them that deal with health-related issues, like workers' compensation statutes and like the FMLA. But the one that we're going to focus on today is the Americans with Disabilities Act. The Americans with Disabilities Act also has confidentiality provisions in it, and you're not allowed. Now, that doesn't mean you can't ask an employee about what their issue is. If they want an accommodation under the ADA, you get to know why. You get to know what health issue, what disability is causing the need for that accommodation. But you can't then share that information with people who don't need to know, and that's going to be important in this particular podcast, and you'll see why in a minute. So, when Chauncey calls you and says, hey, I don't have to tell you why I'm sick, that's wrong. And we've got some guidance under the ADA that specifically says that's wrong. As a matter of fact, we've got two pieces of guidance under the ADA that give us some guidance on what exactly we can ask an employee when an employee either gets sick at work or when the employee calls in and tells you they're not coming to work. First one is the Pandemic Preparedness in the Workplace Guidance. We've talked about that one in this podcast before. It goes back to 2009 when we were dealing with H1N1. It's been updated March, April timeframe to deal with COVID slightly, and it deals specifically with this issue. And the question, as you know, this guidance is in a Q&A format because we've talked about it before. The question that's asked that the EEOC answers is this. During a pandemic, how much information may an ADA-covered employer request from employees who report feeling ill at work or who call in sick? And the EEOC says the following. ADA-covered employers may ask such employees if they are experiencing influenza-like symptoms, such as fever or chills and a cough or a sore throat. Employees must maintain all information about employee illness in a confidential manner. in compliance with the Americans with Disabilities Act. And the update from the EEOC says, applying this principle to current CDC guidance on COVID-19, employers may ask employees who report feeling ill at work or who call in sick questions about their symptoms to determine if they have COVID-19. And then the EEOC says, currently these symptoms include, for example, fever, chills, cough, shortness of breath, or sore throat. As you know, we've got a broader list of symptoms now, and they're coupled a little differently. But that's basically the rule. I can say to an employee, what do you mean you're not coming in? Do you have COVID? Do you have these symptoms? I get to ask that. There's also a second piece of guidance that deals with this specific issue. And it is what you should know about COVID-19 and the ADA and the Rehabilitation Act and other EEO laws. And that guidance has the same basic question and gives the same basic answer. And that guidance was updated as late as September of this year. So you get to ask Chauncey when he says, I'm not coming to work, why aren't you coming to work? Do you have a fever? Do you have a cough? Do you have a temperature? Do you have a sore throat? You get to ask, and Chauncey has to answer you those questions. Okay, so that's what we can ask. Now, what's this confidentiality issue that you're talking about here, Palazzolo? Why is that a big deal? Well, that's a big deal because we've got this MIOSHA final rule now that's got a bunch of requirements in it for what we have to do when we know that we've got an employee with COVID, right? It's the MIOSHA emergency rule, and it creates a reporting requirement on you. And that's Rule 6.4, or 6, it's not 0.4, it's paren 4, 6 paren 4. And that rule, 6 paren 4, requires you as an employer to do two things when you find out that one of your employees is COVID positive. The first thing you have to do is report to the local health department. You have to call the local health department and you have to say to the local health department, I've got an employee that's got COVID. And the second thing you have to do is within 24 hours of finding this out, you have to tell all the coworkers and some other people who might have been in close contact with that coworker that somebody tested positive. All right, that raises two questions. Can I tell those people who the employee is? Can I give them the name? And the answer is yes and no. How do you like that? That's a lawyer answer, isn't it? Yes and no. The answer to the first question, can I tell the health department the employee's name, is yes, absolutely. The answer to the second question is no. Let's talk about the first question first. Specific guidance from the what you should know guidance of the EEOC. And the EEOC is super straightforward on this. The question is, may an employer disclose the name of an employee to a public health agency when it learns that the employee has COVID-19? And the answer, are you ready for this? The answer is yes. No explanation, no discussion, no equivocation, yes. So when you are complying with the MIOSHA emergency rules and you're calling the health department and they want to know the name of the employee, you can tell them. Okay? All right, so that gets us to the second question. Can I tell the coworkers? And the answer to that question is no, because there are confidentiality requirements under the Americans with Disabilities Act. And I can't tell a coworker about another employee's medical condition. I can't. Well, that doesn't make any sense here. I've got to tell them that they might have been in close contact with somebody who's COVID positive. How do I do that? Chauncey says to the manager, well, I'm not coming in because I've got COVID. And Chauncey was at work yesterday. Now what does the manager do? Well, the first question is, can the manager tell his boss and HR? And the answer is absolutely yes. You got to tell the response team under your preparedness plan so the response team can report. Those are people who need to know and can be told. Can I tell coworkers? No, you can't. All right. You talk to the employee and say, who have you been in close contact with? All right. And the EEOC specifically deals with that issue. The ADA does not interfere with the designated representative of the employer interviewing the employee to get a list of people with whom the employee possibly had contact through the workplace so that the employer can take action to notify those who may have come into contact with the employee without revealing the employee's identity. That's the quote, without revealing the employee's identity. But they go on to say you can also use a generic descriptor. Like you could say somebody on the 4th floor has COVID, or somebody in this department has COVID. Now, does that mean people are going to figure it out? Yes, it does. And the EEOC even recognizes that. They say for small employers, coworkers might be able to figure out who it is. Well, they're going to figure it out because they're not at work the next day, right? But that's not a violation of the ADA. Giving the name of the employee is a violation of the ADA. So when this issue comes up, if you've got questions about it, you need to give us a call. We'll walk you through it. And there's some alternatives you might be able to use here that we can talk to you about. That's where we are. That's what you can ask employees who call in sick. There's your confidentiality requirements under the reporting requirements of the MIOSHA emergency rule. Thanks very much. Join us next week. We got a special episode. It's going to be a lot of fun. And we'll talk to you soon. Bye.